Hello blog readers. I'm here today with esteemed class action litigator, partner Jerry Maatman from Seyfarth Shaw. On October 5th, U.S. Attorney General Jeff Sessions issued a statement on behalf of the Department of Justice that the protections under Title VII of the Civil Rights Act of 1964 do not prohibit discrimination based on gender identity per se, including transgender status. Given the importance of this development and how this is a hot issue, Jerry will now give our readers an overview of the significance of this statement, as well as what it means for businesses and for litigation under Title VII. Jerry, briefly, what is the recent history regarding legal interpretation of Title VII in this context?
Well, thank you for having me on today. This development represents an intersection of politics and law. Over the last several years, the U.S. Equal Employment Opportunity Commission began filing cases, passing enforcement guidance memoranda, and working towards a construction of anti-discrimination workplace bias laws to cover transgender status or sexual identity. And this represents a cleavage in terms of that sort of position statement insofar as the Attorney General said the Department of Justice does not agree with that interpretation of the law, and it would strictly enforce the law as written to not cover that particular protected category.
Great. Are there any conflicting statutes or rulings, as Congress has rejected all attempts thus far to amend Title VII?
There are rulings here or there, and there is a somewhat famous case involving the EEOC where transgender status or sexual identity was recognized as a protected category. But the debate goes on in terms of if the statute indeed covered that protected category, why doesn't it say it? Or if it was so self-evident, why wouldn't Congress move to amend the law? And so you have the yin and yang, or the struggle between proponents of a broad interpretation of the statute, arguing that that sort of protected category ought to be included, and those who say the statute as written should be enforced and does not include that particular protected category.
Okay, and lastly, what are the possible implications here? What does the Department of Justice's statement mean for businesses?
Well, I don't think businesses wake up every morning and say, how can I discriminate against someone? They want to be known for the great goods and services that they provide to their customers and the public, as opposed to a black eye that might accompany a discrimination lawsuit that might be filed against them. And there are a patchwork quilt of laws on the state and local level that prohibit this very conduct in terms of discrimination based on transgender status or sexual orientation or identity. So there is protection in this area. So I think it goes back to fundamental HR administration to avoid legal risks in terms of when personnel decisions are made. They're made for appropriate, legitimate business-related reasons rather than reasons involving someone's identity or status. But at least for the foreseeable future, to the extent there's litigation, it's more often than not going to be at the state and local level, or there'll be this ongoing debate between the EEOC and the Department of Justice as to the appropriate construction of federal law in terms of Title VII. But I think there may be an infiltration of politics into this area as the Trump designees that are taking over the EEOC take their chairs and begin to implement their views of policy in terms of the proper or appropriate interpretation of Title VII.
Thank you, Jerry, and thanks to our readers for tuning in for another great vlog. The debate over protections under Title VII is far from over, and readers should stay tuned to our blog and Twitter account for updates on this important legal issue.